Hello to my friends at Stevenson University. This video is about the patent law system of India. First, however, you need to know a few facts about India. India is an ancient country. It is the birthplace of four of the world's major religions. It is a historic center of art, literature, learning, philosophy, and culture. After China, India is the world's second most populous country. With 1.2 billion people, it is the world's largest democracy. In many ways, India is a very modern, advanced country. For example, in space exploration and communications, India has been launching satellites using Indian-made rockets since 1980. The Indian Space Research Organization successfully sent a mission to orbit the moon in 2008. In November 2013, it launched its Mars Orbiter mission, which entered the Mars orbit in September 2014. This made India the first nation to succeed in its first attempt to reach Mars. India is also a world leader in information technology. It has major software development centers in Bangalore, Hyderabad, Chennai, and Delhi. In the fields of pharmaceuticals and biotechnology too, India is a rising star. Despite these achievements, India still struggles with great poverty. In 2014, India's per capita gross domestic product was only $5,777, making it 125th out of 195 countries. In 2011, the World Bank estimated that almost a quarter of the total Indian population, about 300 million people, lived on less than $1.25 per day. A 2014 World Bank estimate found that India had 17.5% of the world's population but had 20.6% of the world's poorest people. Even Indians above the poverty line often have a fragile existence. Many lack basic essentials of life like safe drinking water, sanitation, adequate housing, and healthcare. Malnutrition also impacts the lives of hundreds of millions of Indians. India is a member of the World Trade Organization and has implemented the TRIPS agreement. Until recently, India's Patents Act excluded medicines, drugs, and foods from patent protection. At that time, only the process for making pharmaceuticals could be patented, so that a company could recreate another's product by making changes to the production process. When the Indian Parliament amended the Act in 2005, it removed the ban on patenting pharmaceutical products. India claims that its patent law is consistent with the TRIPS agreement. However, many pharmaceutical companies argue that the Indian law does not adequately protect their products. One area of concern for foreign companies is Section 3D of the Patents Act. It provides in part the mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance cannot be patented. When applied to pharmaceuticals, Section 3D means that a small change in a known drug molecule, one that doesn't improve its effectiveness, is not an invention that can be patented. This provision is intended to prevent a practice called evergreening. Evergreening means getting a patent monopoly over an updated drug that doesn't represent a major advance over earlier versions. In 2013, the Indian Supreme Court rejected an attempt by the Swiss firm Novartis to get a patent for its leukemia drug Glivec. Glivec's active ingredient is a new salt form of an earlier compound that Novartis had patented in many countries but not in India. The court said that Novartis failed to prove that Glivec was more effective than the earlier drug from which it was derived. One effect of the ruling is that Indian companies can sell generic version of Glivec at about 1/20th of the 70,000 US dollars that it costs for a year's treatment in the US. The Glivec case drew a lot of criticism from drug companies. So did a similar decision in January 2015 when the Indian Patent Office rejected a patent for a hepatitis C drug made by a US company. A second area of concern about India's patent laws is compulsory licensing. A compulsory license is a government order allowing someone to use a patented invention without the patent owner's permission. It usually requires payment of compensation to the owner. The compulsory license can be used to manufacture or import generic medicines. Under the TRIPS agreement, countries have the right to grant compulsory licenses and to determine the grounds on which they are granted. The Indian Patents Act allows anyone to request a compulsory license if, after 3 years from the date a patent is granted, one of the following is true. The needs of the public to be served by the invention have not been satisfied. The invention is not available to the public at an affordable price, or the invention is not manufactured in the country to the fullest extent possible. In 2012, the Indian Patent Office granted its first compulsory patent license for a pharmaceutical product. It allowed an Indian company to manufacture an anti-cancer drug patented by German pharmaceutical company Bayer AG. The effect is to allow production of a low-cost version of the drug for the Indian market. Pharmaceutical companies and foreign governments have criticized India's patent system. They have put pressure on the Indian government to tighten its intellectual property laws. In January 2015, Indian Prime Minister Narendra Modi agreed with US President Barack Obama to create a joint commission to look at this issue. Only time will tell whether this difficult issue will be resolved to everyone's satisfaction.
Oh.